Hello everyone, my name is Suhani Agarwal and I study in class 8B and I am going to explain the topic judiciary system in India. Judicial system or the court system is also the judiciary system. The court has the power to make decisions and also enforce the law, solve disputes. Judiciary system consists of judges and other magistrates. They form the bench or the core of the judiciary system. On 26 January 1950, the Indian Constitution was written and it's world's largest constitution written. The Constitution is the source of law in India and also the supreme law of India. Judicial system of India consists of Supreme Court, High Court, District Court or subordinate court. Under the Constitution of India, the Supreme Court is the final court of appeal. Hence has the Chief Justice of India, including 30 judges and other judges for advisory jurisdiction. Unsolved or still in dispute cases are leveled up to Supreme Court and to retain justice. If the Supreme Court declares a law, it is binding on all other courts of all states and union territory. Every court building has 15 courtrooms. The eligibility to become a Chief Justice is the judge in one High Court or more for at least 5 years or advocate in High Court for at least 10 years. A distinguished judge in the opinion of the President of India. Under the Constitution of India, every state should regard to one High Court. Mumbai High Court, ID, the oldest High Court in the world. Every High Court has 94 judges, out of which 71 are permanent and 23 are additional judges. High Court deals with economic issues and legal documentations. These courts also have an additional set of legal professionals. Eligibility for a High Court judge is he should be a citizen of India. An advocate should have at least 10 years of practice in any court. Dispute resolution. The judicial system provides a mechanism for resolving disputes between citizens and the government, between two state governments, and between the center and state governments. Judicial review. As the final interpreter of the Constitution, the judiciary also has the power to strike down particular laws passed by the Parliament if it believes that these are the violation of the basic structure of the Constitution. Upholding the laws and enforcing fundamental rights. Every citizen of India can approach the Supreme Court or the High Court if they believe that their fundamental rights have been violated. Judicial independence is the concept of that the judiciary should be independent from the other branches of government or the politician in office. That is, courts should not be subject to improper influence from the other branches of government or from private or partisan interest. Judicial independence is important to the idea of separation of powers. For example, imagine a situation in which a powerful politician has encroached on land belonging to your family. Within this judicial system, the politician has the power to appoint and dismiss a judge from his office. When you take this case to court, the judge is clearly partial to the politician. The control that the politician holds over the judge does not allow for the judge to take an independent decision. This lack of independence would force the judge to make all judgments in favor of the politician. Although we often hear of rich and powerful people in India trying to influence the judicial process, the Indian Constitution protects against this kind of situation by providing for the independence of the judiciary. There are three different levels of court in our country. There are several courts at the lower level, while there is only one at the apex level. The courts that most people interact with are what are called subordinate or district courts. These are usually on district or tehsil level or in towns, and they hear many kinds of cases. Each state is divided into districts that are presided over by a district judge. Each state has a high court, which is the highest court of the state. At the top is the Supreme Court that is located in New Delhi and is presided over by the Chief Justice of India. The decision made by the Supreme Court are binding on all other courts of India. There are two different branches of the legal system, criminal law and civil law. In criminal law, deals with conduct or acts that the law defines as offences. For example, theft, harassing a woman to bring more dowry, murder. It usually begins with lodging of an FIR with the police who investigate the crime, after which a case is filed in the court. If found guilty, the accused can be sent to jail and also fined. In civil law, it deals with any harm or injury to rights of individuals. For example, disputes relating to sales of land, purchase of goods, rent matters, or divorce cases. A petition has to be filed before the relevant court by the affected party only. In a rent matter, either the landlord or a tenant can file a case. The court gives the specific relief asked for. For instance, in a case between a landlord and a tenant, the court can order the flat to be vacated and pending rent to be paid. All citizens of India can access to the courts in this country. This implies that every citizen has a right to justice through the court. The courts play a very significant role in protecting our fundamental rights. If any citizen believes that their rights are being violated, then they can approach the court for justice to be done. While the courts are available for all, in reality access to the courts has always been difficult for a vast majority of the poor in India. Legal procedures involve a lot of money and paperwork, as well as take a lot of time. For a poor person who cannot read and whose family depends on a daily wage, the idea of going to court to get justice often seems remote. And a rich person can reach easily in the court because he has a lot of money and popularity. But every person have a right that who can reach in the courts.